Not every clinical negligence claim will require the court's involvement. The initial stages of the investigation are often carried out before the court is notified of a claim, and many cases are brought to a successful conclusion without the need for court proceedings. It may be necessary to start court proceedings for a number of reasons. For example, the limitation period is due to expire, or during the initial stages, the defendant denied the claim and court proceedings are started to progress to the next steps in the litigation process. Or, during the initial stages, the defendant made admissions in the claim and court proceedings are started for judgment to be entered and to obtain payments on account of the eventual compensation award. Court proceedings are started by lodging a claim form with the court. This is known as issuing court proceedings. Once a claim form has been issued, we must serve the claim form and other specific documentation on the defendant within 4 months. In addition to the claim form, we need to provide the defendant with a document called the particulars of claim, which is often prepared by a barrister, and will set out the allegations of negligence and consequences of the negligence. We also serve a valuation of the claim on the defendant. Once the documents are served, the defendant serves a defence. The defence is a response to the allegations and the particulars of claim. The defence may admit the claim, or parts of the claim, or deny the claim. After the defence is served, the next key step is for the court to set a timetable for the procedural steps necessary leading up to, and if settlement cannot be agreed, trial. The timetable to trial will include the disclosure of relevant documentation, the exchange of witness statements and expert evidence, and the service of a final schedule of loss and counter-schedule. After both parties' evidence is served, the experts on both sides, in the same areas of expertise, will need to meet to discuss their opinions in order to ensure their points of agreement, disagreement, and reasons for their views are clear. Both sides are encouraged to engage in alternative dispute resolution or mediation before a trial, and often a round table meeting will take place to discuss the issues in the case and to see if a settlement can be reached. This step can take place at any time during the claim, although most often takes place after expert meetings have been completed. In the overwhelming majority of cases, settlement is agreed and there is no need for the case to go to trial. However, it is vitally important that every case is prepared on the basis that there will not be an agreed settlement and trial will take place.